so stupid.
Hello viewers, welcome to our program on Immigration and You. I am your immigration attorney Michael Phulwani. My associate Madhvi Samudrala is on vacation, but today I have two very special guests. I have with me here today Mr. David Nachman, who is an immigration attorney with an experience of over 20 years, and both of us, we go a long way back, and we have spent years and years here in practicing immigration, U.S. immigration law. Now, before I introduce my other guest, I just want to tell you that we had a lot of calls and emails and letters from time to time from many of you guys, viewers. What about Canadian immigration? Why you guys cannot tell us on the Canadian immigration? And I say because we are not Canadian immigration lawyers, but we have with us in our group a very experienced Canadian immigration lawyer in the US. Remember, most of the Canadian immigration lawyers are in Canada, so you need help on Canadian immigration. Probably you have to call somebody in Toronto, Montreal, or Vancouver, whatever. But that is the very big advantage we have, that we have this experienced immigration attorney. She is Felicia Zeidman. Felicia, welcome, and David, welcome. Few words. Let me say a few words about Felicia, because you are pretty well known also, just like I am.
Please.
Okay, Felicia is a Canadian lawyer since 1999, which is a lot of years in experience, right? And you have a lot of background in Canadian immigration law, as well as it relates to the criminal issues that come from the border crossing between Canada and the US. Of course, I know that you handle all kinds of Canadian immigration matters like business, employment, temporary visas, permanent visas, green cards, and many questions we have to ask you. So Felicia, before we start asking you questions, David, do you have any comment to make about Felicia, because you know her also better?
Well, Michael, I've been working with Felicia very closely for several years now, and one of the things that Felicia is able to bring to the table, one of the unique skill sets, is that because she was a prosecutor previously in Canada, she has sort of a bird's eye view of the criminal process up there and how the authorities look at certain issues. So that's one of the unique skill sets she brings to the table. Another one is that she is involved in the business immigration arena, both U.S. and Canadian, and assists us with just the myriad of issues that confront us on a day-to-day basis in that area.
Thank you, and thank you also, Felicia, for coming today again. Let us start with a question that is very common, because people ask us all these questions. What's the difference between a U.S. immigration law and a Canadian law? But what I understand, and you can explain that better, is that U.S. immigration law has certain specific categories. Family, first preference, second preference, third preference, fourth preference, employment, first, second, third, fourth, and a person has to fit into each category. And I believe the Canadian system is somewhat different. Also, there's a big problem in the waiting periods in the US, because some of the categories like brother, sister of a US citizen may take 10 years, 12 years. Unfortunately, even other categories, the family third preference, family first preference, it's just getting longer and longer. I believe that Canadian waiting periods are shorter. So let us start. Give us a brief overview of the Canadian immigration law compared with the US immigration. Then David and me may have more questions specific to ask you.
Thank you very much, Michael. The difference between Canadian and American law, I think, is situated in what drives the immigration process. The gold standard of immigrating to Canada, to become a permanent resident in Canada, and then later down the road, not so much later down the road, a citizen, is available to people who are first and foremost in an occupation that's under pressure in Canada. There's a list of 29 occupations, and applications are taken for these 29 occupations, which run the myriad of types of occupations, from a crane operator to a social worker to a food and beverage manager. So there's all kinds of occupations.
But don't you have the same system in order to become a Canadian citizen? you must first be a Canadian permanent resident?
Yes, in order to, yes, you have to be a permanent resident, but it's achieving permanent residency that people from abroad.
So you're talking about achieving permanent residency.
I am, and once you're a permanent resident for a few years, you can become a citizen.
What is few years? There's a, like we know in the US is 5 years, or 3 years if you are married to a US citizen. What about Canada?
It is, if you're a permanent resident for 3 years out of any 4 years, you are able to become a citizen. So that's the waiting period, but really it's permanent residency. Once you've achieved permanent residency, that's a very nice status to have in Canada. And a lot of people remain permanent residents without becoming citizens, of course. I think they do that in the United States too, because they're getting everything that they want as permanent residents. So the real trick, the real question is, how do we get a person in as a permanent resident? And the beauty of the Canadian system that I'm describing to you, where you fall under one of the occupations, is that you can do everything from your home abroad in a period of, let's say, between 1 and 2 years, and you walk into Canada with your green card. I'm calling it a green card. Your permanent residency.
Canadian.
Yeah. And so...
You don't say a green card there, but it's
no,
similar
we don't have
to
a green card.
Yeah.
Even the green card in the United States is not green, but who's getting picky? So the issue is that we have this system that allows people to come in as permanent residents, and that's the gold standard. That's one way to come to Canada. There's many other ways to come in. You can come in as a worker, and after a number of years as a worker, apply for permanent residence as well. That's the Canadian Experience Class, because the Canadians have decided, in what I think is a very wise move, that if a person is experienced in Canada and has worked in Canada and has shown have shown themselves to be adaptable to Canada, they're an excellent candidate for becoming a Canadian permanent resident. So the system becomes smoother for them, easier for them, that as they work in Canada, it becomes a little bit of an easier road to become
Let's talk about very quickly temporary visas.
Yes.
We can come back to the immigrant visas.
Sure.
We have lots of questions to follow up on whatever you are telling us. Something like we have H1 visa.
Yes.
Something like we have an L1 intra-company transfer
Yes.
visa. What about persons want to just to study, and how easier or difficult it is to get any of these visas? What is the process, how much time it takes to do so? Because we have a lot of people here in different situations. We'll talk about people who are deportation or who have criminal background or other issues. That's a separate subject.
Sure.
We follow up later. But in terms of generally speaking, somebody's here for some reason, he cannot extend the status, change the status, and he's, instead of going back to India, Pakistan, Bangladesh, he says, okay, why can I not go to Canada and stay there at least for a certain period of time until I can immigrate back to the US or just settle down in Canada? Tell us all about that.
Okay, well, a temporary entry to Canada is available for workers, for students, and for people who want to visit. Those are the general categories that usually people find themselves coming temporarily to Canada. And when a person comes temporarily to Canada, just like the United States, they have to prove that they have some ties to where they come from, especially if they're just coming as a visitor. But if they're coming to work, they have to prove that there's a job for them. And if they're coming to study, they have to prove that they're genuinely going to go to school in Canada. So it's not rocket science in the sense that it all makes sense, but it is getting more and more difficult to prove that you're coming in only temporarily and that you're coming in to do what you're going to do. I help a lot of people who are coming in as students and as visitors because the majority of countries in the world require a visitor visa. There are some countries that do not require a visitor visa to Canada, countries like the United States and England, what we might generally think of as the Commonwealth countries, not all of them. But, for example, not India and not South Africa. But there's many, many countries. So
do U.S. green card holders need a visa?
They do not.
They do not.
They don't. But if they're coming to work, they need a work permit. Right. So these are two very separate things. You need a visa to get into the country, but you don't need a visa if you're coming in for a week and you're coming from the United States, for example, and you're a green card holder or a citizen.
Let me take a very specific question.
Sure.
We have a guy here who is working in the U.S. H-1 visa. But for some reasons, he was laid off, he stopped working in H-1. So once he's not maintaining the status, he's not going to be able to change the status, and he doesn't want to take the risk of going out of the country, trying to get a visa from the consulates, because consulates go much deeper into a lot of these issues. He says, why can I not go to Canada for some period of time? His green card is already in process, and that will continue even if he goes and stays in Canada. So how does it work in technology? He got H1, he got a college degree. What does he exactly need to get the temporary work visa in the field of technology?
So he needs a job offer. That's the best thing to have. The great thing about a person who has status in the United States and is trying to get a job in Canada is that it's very easy for them to go over the border and interview for that job. But if they do not have status in the United States and they're looking to come to Canada, they can do so, they can get a visa as long as they have been in the United States for a certain length of time. There are some questions about whether or not they can apply from the U.S. It's very complicated, and it's really good to consult with a lawyer. But ultimately, coming to Canada for a temporary period is a very viable option.
But what we need, my question is specific, is what does this guy need? Because from what you told me, if he is in valid status, he can come to Canada for interview. But this is a little tricky question and a tricky answer. He has a valid H1 status for another 2 years, valid. Right. I-94 is valid, stamp is valid, but he stopped working. Now that's a problem related to U.S. immigration, because in order to extend visa or change from H1 to something, he must have to prove that he is still maintaining H1 status. But in response to what you said, that may not be necessary as long as he has got a valid H1 visa on the passport and a valid I-94 with a period of time. He can probably still travel to U.S.
To Canada.
May not be you may have a little problem maybe coming back. He can go to U.S. or Canada, right. I'm sorry.
I wouldn't want to comment on him coming back. That's for you guys.
Yes.
But for actually for coming to Canada, if he's in valid status here in the United States, he will likely be able to come from the United States. I wouldn't want to say 100% because I'd want to think about the situation a little more and talk to him. But even if he couldn't come from the United States, he might be able to come from his home country. So the application might be able to be made from his home country if he's prepared to do that.
But does it take much longer time if he tries to come from the home country?
Not always. Not always. All the countries have different processing times, and many of the countries are quite fast.
But
so some of them even
permanent
faster
visas,
than the United States.
I was told, maybe I'm wrong, that especially for permanent visas, when to immigrate, a person applies in New Delhi or in India or in Pakistan or Bangladesh, it takes much longer time as compared to whether he was in United States. Is that true? Or?
I think that might be true in some of the places you mentioned, but I think that there is actually a very good parity between many of the countries that you mentioned and the United States. Okay. The United States is not the fastest, surprisingly, in terms of processing.
UK is probably. No. Yes.
I haven't looked because I don't have the opportunity to send people. Like it only depends where the people are from. Okay. So I only look up the specific countries they're from. I can rarely say to people, well, can you go to Guam and apply from there? I can't do that. How about
section, like we have section 214B. Person wants to come to study in Canada. Now, U.S. consulate goes very deeper into 214B. That means he has to prove the intent that he will come back to India after completing the studies. And many cases are denied for that reason. How does it work in Canada? Is that a very big factor in somebody in India coming to study in Canada?
It's not the biggest factor, whether or not they're going to go back. But it is a temporary visa. And like all temporary visas, the person has to prove ties to that home country to show that they're not going to overstay. And in fact, where an interesting point that may be of interest to your viewers is that if they've overstayed in the U.S., for example, that does not look good for a temporary resident visa application.
I think we are running out of time. So we thank you very much for coming on the program, Mr. David Nachman and Felicia, and all the viewers for watching our program.
Thank you.
Felicia, we're going to request you to come back again next week, and we can discuss more about Canadian immigration. And if you have any questions to our viewers, comments or suggestions, please contact us. And I'm sure that any questions on Canadian immigration, Felicia will be happy to answer. So please make sure to watch us next Sunday at 11:15 a.m. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman and Felicia Zeidman, who is the Canadian immigration attorney. Remember, she was on this program last week, and a lot of nice information, valuable information she provided us on the Canadian immigration law, and we want to continue further discussion on the Canadian immigration law because a lot of you guys are interested. Some people who want to immigrate and settle in Canada, some people have found out that there's no chance now in getting a immigrant status in US for a long time unless there's a change in the law. And some of these questions come from people who have been ordered deported, some people who might have some kind of criminal issues. And I'm going to request Felicia to tell us about a person who applied for political asylum was denied, or put in deportation proceedings, and now he has got a final order of deportation and not much chance of getting anything done here. Or somebody that who might have some kind of crime which is a little more extensive, probably depending on the type of crime and all that. So, what do you say?
Well, a person who's applied for political asylum who never had asylum, who just came to the country of the United States and came as a visitor and never had asylum, would have, I believe, difficulty with applying to immigrate to Canada from the U.S. They would still be able, like anybody, to apply to immigrate from their home country, and it might become the best thing for them to do so from their home country. So it's open to them. It's not considered a criminal conviction. Now, a criminal conviction, which was the second part of your question, does cause problems for immigrating to Canada. There's a couple of what we would call in the United States waiver kind of possibilities for getting in. There's a temporary residence permit and there's a rehabilitation application. One of them, obviously, as you can tell by the name, is temporary, to come in on a temporary basis, and one of them is permanent, that's rehabilitation. Depends a lot on the type of crime and when you were convicted of that crime as to when you will be allowed to come into Canada.
Well, let me follow up this question. Somebody who has got an order of deportation is already outstanding warrant of arrest because of the deportation order. No crime, nothing. Only thing is he came even without a visa or with a visa, applied for a political asylum, and he could not prove whatever the factors are required for getting a political asylum. So he has a deportation order. Are you saying that that person cannot get Canadian permanent resident status, or he can and it's difficult, or whatever the position is on that issue? There are a lot of them. The reason I'm asking you, we know, between me and David also, we have a lot of clients who have an outstanding order of deportation coming from the application for political asylum. Some come from other issues too. But in principle, what's the story on this?
If we're talking about a person who has simply been denied asylum, basically, and has been ordered deported as a result of that, in a general case that is not considered a criminal conviction, right, and that would be something that would not get in the way of an application to come to Canada on a permanent basis. If you were going to come in on a temporary basis, I think it might get a little dicier, but it still would be on a case-by-case basis. Okay,
so that's, I think, pretty much clear. My question was mainly for people who want to immigrate to Canada, and that you said will not be a problem.
It's definitely worth looking at. Okay. It has high probability.
No, I understand. On a case-by-case basis, always we say that it's never like like going to ShopRite and picking a green card there. But generally speaking, the law permits them. They can still try to get permanent resident status.
That's right.
Okay. David, you had a question.
Yeah, Michael, I think one of the important things to point out here is that the reason why we're talking about Canadian immigration and why Canadian immigration has become such a poignant issue for everyone lately is because individuals who are pursuing their options in the U.S. immigration realm also can simultaneously pursue their options in the Canadian realm. They're not precluded from doing those simultaneously. Is that right, Felicia?
Absolutely. It's a great opportunity to keep your hands in two systems at once and see which one is going to play out for you.
Very good. Let me follow up on that question. I understand a person cannot have both. like a U.S. permanent resident status green card and also a permanent residence in Canada. Because we have seen some cases where a persons who are green card holders and they are traveling to Canada and actually live in Canada or settle in Canada or get a Canadian permanent resident status, the U.S. Immigration Service believes that they have abandoned their permanent residence in U.S. Some of the cases when they apply for citizenship also, they see that they also obtained. By obtaining a permanent resident status of Canada, I believe the U.S. government, U.S. immigration law says that you have abandoned your permanent resident status.
I'd like to address that just by saying it's my understanding that there are issues definitely with abandonment of the green card and the amount of time you spend outside the United States if you're a green card holder. But I don't know that that necessarily precludes your ability to obtain lawful permanent residence.
So my question
in Canada.
again to Felicia is, can you be a permanent resident of both countries? Can you? Is that Canadian law? What the Canadian immigration law says?
I see nothing to prohibit that from a Canadian perspective.
Okay.
Yeah, and I think that I've seen that too. I've seen several individuals who have come into our office with cases where they are pursuing both at the same time. And a person might be a lawful permanent resident in Canada, seeking lawful permanent
Let's talk a
residence
little
in the
bit
US.
about the processing times. A temporary visa like a work visa, whether a person is applying from US or India, wherever, how long does it take? After the client comes to you, he says, I have got a job offer and I want the temporary visa.
Yes, a temporary visa is actually quite quick in the world of immigration. It's usually a matter of a couple of months. Of late, this summer we've seen terrific delays at the American consulates because they've been putting in a new computer system. And apparently there's a volume issue as well. But as a general rule, I've had student permits roll out in 14 days. Worker permits are a little longer because there's more to do. The employer on the Canadian side has to advertise for a couple of weeks, and so there's things that slow the process down, but it can be done within a matter of months. So it's pretty fast.
Can you tell something about Nafta?
Yes, I want to address
What's Nafta, first of all, or viewers may not know even,
Well, NAFTA stands for the North American Free Trade Agreement. And obviously that affects both U.S. immigration to Canada and Canadian immigration to the United States. But Felicia, tell us how NAFTA impacts Canadians, U.S. Individuals, people in the U.S. or elsewhere going to Canada.
Well, we love NAFTA because NAFTA allows a worker in as long as they fit under a specific profession, and it's quite a lengthy list of professions, and if they're coming over to do a job that is specifically related to that profession, they can either come from it's Canada, Mexico, and the United States, and they can come in to any of those countries from the other country. The agreement is a tripartite agreement. They can come into the country and do the work without a work permit. So they don't need a work permit. And basically the sort of avoids those few months of waiting time and getting approval for that.
The person has to be a U.S. citizen?
Has to be a U.S. citizen.
In order to benefit from the NAFTA?
If they were going to go, yes. If they were going to, let's say they were going to go from the U.S. to Canada.
Yeah.
But the reason that it's useful to discuss it in this arena, let's say for somebody who cannot stay in the United States and is not a citizen of the United States, is that if they come to Canada and become a citizen of Canada, they can come back to the U.S. as a worker under NAFTA. So they don't have to think about all of this H-1 stuff. They come in under NAFTA.
Is the TN visa coming from NAFTA?
Yes, sorry, okay. TN is what it's called on the American side.
David, you want to tell about TN visa?
Well, the way that works, Michael, and Michael and I probably do lots of and they're not really visas, they're actually classification under Section 1603D1, which is an annex that's attached to the North American Free Trade Agreement, where there's a list of professions and the educational requirements. Once an individual has a job offer, they can enter the United States and they're able to work in that classification for their employer. The only thing that you have to be careful of, which is a lot of the areas where we get questions, can you self-sponsor for NAFTA? And the answer, unfortunately, is you can't.
Also, from what I understand, there is something similar to 214B issue on TN visas. In other words, TN applicant or TN person should not have an immigrant intent. And if a person has applied for an immigrant visa, married to a citizen, or a labor certification or something, and then that problem, there may be a problem for a TN person, or to even renew the TN visa.
It's absolutely right, Michael. In fact, what we generally do is when a person has entered in a TN classification, remember that Canadians are visa exempt, so we call it TN classification. Yeah. Once they've entered the United States in TN classification, you have to move them if you can. And by the way, TN's now 3 years.
Yes.
It used to be 1 year, now it's 3 years. And we generally try to move people to H-1B,
yes,
a dual
exactly,
intent classification.
We change TN to H-1.
Right, and then we go from H-1 to the green card so that there isn't a conflict in the underlying intent, exactly. And more we're seeing this issue come up where individuals who may have an underlying I-130 or may have some kind of a labor certification filed, and then they have a TN and they try to cross over the border, they may get stopped by an officer who's questioning that underlying immigrant intent.
How long does somebody wants to immigrate permanently to Canada? Comes to you.
How long does it take?
Yeah.
Well, the actual getting the paperwork, it's not a small thing to get all the paperwork together. It takes a number of weeks. But once all of that is done, the process can take, I would put it at anywhere between 1 year and 2 years.
2 years also.
It can go up to 2 years. You know, I think it depends on how simple the case is on the side of the bureaucracy in Canada to be able to figure it out. It shouldn't take more than, let's say, 16 to 18 months, but it certainly can take up to 2 years, and in some cases even longer. Each country has different processing times, so it's really worth investigating.
Correct.
A big issue in the news, Michael, lately has been investors in Canada. And I'm wondering whether Felicia might be able to elaborate a little bit on the investor classification in Canada and what's going on there. That would be helpful to our clients to know.
Exactly.
Sure. For many years, Canada was a cheap country to get into. Forgive me for using that term, and to our Canadian viewers. It used to be that you only had to invest a little bit under $500,000, and you had to be worth about $800,000 in order to, and when I say worth, I mean you had to have assets worth $800,000 in order to make the investment. Today, you have to be willing to give the government $800,000 for 5 years, and you will get the principal back, but you will not get any of the interest. The interest goes directly to the Canadian government. So you hand the Canadian government $800,000, and you yourself have to be worth $1.6 million. So it's getting to be a more expensive prospect, but for somebody who is business savvy, it's an excellent option actually. If they're prepared to forego the interest on that $800,000 for the 5 years, and it's a very safe investment, and it's done through the banks and certain safe investment houses.
But what about the person who doesn't want to give money to the Canadian government? He wants to come to Canada to start his own business.
Sure.
Let us say a restaurant, let us say a hotel, let us say a chain of pizza stores or whatever. Mm-hmm. That's different, correct?
That is different, and that person falls under an entrepreneurial class, a business class entrepreneur, and there is an option for them, and it has to do with how many jobs are they going to create in Canada, how much equity do they have in the business that they've been running in their home country or in their resident country. And so Canada really wants to know that they're capable of running a business, but the option is certainly there for them.
Well, we need to also talk about family preference categories, but I think today we don't have much time. But hopefully we can request you to come back again and tell us, as compared to the US family preference categories, where time periods sometimes go 7 years, 10 years, even more. Canada has much less time, I believe. The US green card holders cannot sponsor the parents, but I believe in Canada they can do, and many other issues related to the family preference categories. Felicia, we thank you very much. We'll call you again our next program.
Terrific.
And we can discuss many, many more questions we have. I'm sure our viewers love to hear more about Canadian from such a pretty lady and a most experienced Canadian attorney.